Hi friends, this is CMA Deepika Bhugra Prasad, Insolvency Professional. Ever since its inception, IBC has been a great learning experience for all of us. So let us collectively delve into some important judicial pronouncements under this Act. So I welcome you to Insolvency Insights, a snippet series curated by me, to delve into such important judicial pronouncements and also to navigate through the intricacies of the proceedings under the law. So let us discuss one landmark case today. So this is the case of Dilip B. Jiwrajka versus the Union of India, which was decided on the 9th of November 2023 by the Honorable Supreme Court of India. Now, in its decision in the matter of Dilip B. Jiwrajka versus the Union of India and others, a three-judge bench of the Honorable Supreme Court dismissed a batch of 384 petitions, collectively known as the writ petitions, which were filed under Article 32 of the Constitution of India, 1950, assailing the constitutionality of sections 95, 96, 97, 99, and 100, which were collectively known as the impugned provisions of the Insolvency and Bankruptcy Code 2016, pertaining to initiation of insolvency proceedings against individuals and partnership firms, as codified in Part 3 of the IBC. So let us today discuss the key contentions raised before the Honorable Supreme Court in the writ petitions and the observations made by the Honorable Supreme Court in regard to these contentions. So let us see the factual background of the case. Following the enactment of the IBC Code 2016, the position of the creditors has been strengthened with respect to realizing their dues, including in the case of the position of personal guarantors under the Indian insolvency regime. Personal guarantors were incorporated under Part 3 of the IBC, related to individuals and partnership firms, by its central government notification dated November 15, 2019. Part 3 of the IBC contains the legal framework for insolvency resolution and bankruptcy of the individuals and partnership firms. The provisions of Part 3 of the IBC were brought into force only insofar as they relate to the personal guarantors to corporate debtors. The constitutionality of the notification, which enforced the provisions of Part 3 of the IBC only to a select category of persons, that is, personal guarantors, was upheld by the court in Lalit Kumar Jain versus the Union of India. In the meanwhile, various writ petitions were filed before the Honorable Supreme Court, challenging the constitutionality of the impugned provisions on the ground that the impugned provisions are in contravention of Articles 14 and 21 of the Constitution. Now, before discussing the challenges raised in the writ petition and the observations of the Honorable Supreme Court in this regard, let us discuss the contents of the impugned provisions. So, Section 95 of the IBC is the first. Now, a creditor may file an application to initiate insolvency resolution process against the debtor jointly and individually or through a resolution professional, along with the necessary information and documents relating to, number one, debts owed by the debtor to the concerned creditors, and default by the debtor to pay the debt within 14 days of the service of the notice of demand, and the relevant evidence of such default or non-payment of debt. Next is Section 96 of IBC. So when an application is filed for initiation of insolvency resolution process, either by the creditor under Section 95 of the IBC or by the debtor itself under Section 94 of the IBC, an interim moratorium comes into force in relation to all the debts of the debtor, during which period any legal action or proceeding pending in respect of any debt shall be deemed to have been stayed. And initiation of any legal action or proceeding in respect of any debt by the creditors is prohibited. Now let us see sections 97 and 98 of the IBC. Upon filing of the insolvency application, the adjudicating authority shall appoint a resolution professional, basis the nomination or the recommendation of the IBBI. The RP may also be replaced if requested by the creditors or the debtors. Now, Section 99 of the IBC. The RP is required to examine the insolvency application filed before the AA and make a recommendation on whether the application should be admitted by the adjudicating authority. Towards this end, the RP may require the debtor to prove repayment of debt claimed as unpaid by furnishing evidence of repayment and may seek further information or explanation in connection with the application as may be required from the debtor or the creditor or any other person who, in the opinion of the RP, may provide such information, in which case the person from whom information or explanation is sought is required to provide such information within 7 days of receipt of the request. Basis the information, documents received, and after examining if the insolvency application is complete and in accordance with the provisions of the IBC, the RP files a report before the adjudicating authority, recommending the admission or rejection of the insolvency application. Then is Section 100 of IBC. Within 14 days of the date of filing of the RP report, the adjudicating authority is required to pass an order either admitting or rejecting the insolvency application. In the event the application is admitted, the individual or the partnership firm in question is subjected to insolvency resolution process in terms of Part 3 of the IBC. Now, what were the challenges to the constitutionality of the impugned provisions? Now, in the writ petitions, the constitutionality of the impugned provisions was assailed on the following grounds. Firstly, the scheme under Part 3 provides for the appointment of an RP, even prior to the admission of the petition, and without judicial determination of jurisdictional questions, such as the existence of debt by the AA. Secondly, the powers provided to the RP under Section 99 of the IBC are too wide and are judicial in nature, making them ultra vires to the object of the IBC. Thirdly, the appointment of the RP and the initiation of an interim moratorium without providing an opportunity for the personal guarantor to be heard in the front of a judicial body are arbitrary, a violation of principles of natural justice, and a violation of Article 14 of the Constitution. Now, what are the observations of the Honorable Supreme Court? The Honorable Court analyzed the contentions of the petitioners and divided its observations into primarily 4 parts. The court in its analysis noted that the RP exercised any judicial role under Part 3, but that of a facilitator and is limited to the collection of information. The court highlighted that the IBC specifically used the terms examine the application, ascertain, or satisfies the requirements and recommend in relation to the acceptance or rejection of the application. These statements clearly indicate that the resolution professional is not meant to engage in an adjudicatory role or make any judicial determination regarding the facts. It further noted that since the threshold of default for filing an application is only rupees 1,000 as per Section 78 of the IBC, the AA would be overburdened if all amounts of alleged defaults as low as 1,000 rupees were to be judicially determined. Thus, the RP acts as a facilitator by collating the data and information in relation to the application filed and recommends that the AA either rejects or accepts the application. Secondly, the court clarified that the interim moratorium under Section 96 of the Code is intended to be protective in nature, in contrast to the moratorium provided under Section 14, which restrains the transfer, encumbrance, alienation, or disposal by the corporate debtor of any of its assets or any legal right or beneficial interest thereon. The court further noted that the interim moratorium primarily applies to a debt rather than a debtor. The court noted that the determination by the AA under Part 3 begins when the resolution professional submits a recommendatory report. This is clearly distinct from the IRP for corporate provided under Part 2, where the AA is the first forum for jurisdictional confirmation before the appointment of RP and the placement of a moratorium. The court further emphasized that the AA does not blindly accept or reject applications purely based on the report submitted by the RP. Instead, it provides the debtor with a fair chance to be heard before the AA under Section 100 of the IBC. In its fourth part of its analysis, the court clarified the principle of natural justice is not violated for primarily two reasons. Firstly, the judicial determination of the question of facts arises under Section 100 only after the submission of the report by the RP. At this stage, the court conducts an independent inquiry to reach its conclusion, and the debtor is allowed to make its submissions and get its right to be heard before the admission of claim against him or her. Secondly, even at the stage of investigation by the RP has the authority to demand proof of debt repayment from the debtor. Thus, the provisions of Section 99 make it clear that the process before the RP is not ex parte, and a just opportunity is provided to the debtor to furnish his case. Therefore, at both the stages of determination under Part 3, the principles of natural justice are being followed by giving ample opportunity to the debtor to furnish his case before admission of the insolvency application. So, friends, we conclude that the insolvency regime of personal guarantors has great significance for all stakeholders, including creditors, debtors, and the Institute of Guarantee stakeholders. The instant judgment aims to pave the way for the disposal of the massive number of applications pending against the personal guarantors, aiding the creditors' debt recovery and boost their confidence. However, we should not lose sight of the importance of protecting the rights of personal guarantors, as this may also pose a serious hindrance to the flow of credit in the absence of sufficient guarantees provided by the personal guarantors. So, friends, we see that how the law is really trying to change the economic landscape of our country and really trying that the creditors must be able to recover their dues in a just and fair manner. So, friends, I trust that you find this both engaging as well as enlightening. So, for further insights into such key judgments under the IBC, please like this video and subscribe to my YouTube channel. Thank you very much for being here with me today. This is Deepika B. Prasad signing off, and we'll catch you in the next case. Thank you.